Hello and welcome to Supreme Court Now. My name is Luis Civalledo, and today we're going to be looking at 3 more court cases that the Supreme Court of the United States is going to be looking at this week. The first of these cases is going to be Rutledge versus PCMA, or Pharmaceutical Care Management Association. The second is going to be Tanzin versus Tanvir. And the third, last but not least, I should say, is Google LLC versus Oracle America, Inc. And with that, let's get into the cases. Tanzin versus Tanvir. Now, an interesting thing about this case is that it is Mr. Mohammed Tanvir versus FNU Tanzin. And FNU stands for First Name Unknown, because we have an FBI agent involved in this case. So, a little background on this case. Mr. Mohammed Tanvir, who is a plaintiff, is a Muslim living in America legally, specifically New York City. And he was approached by FBI agent Tanzin on grounds, and Mr. Tanzin basically said, hey look, you and your buddies are going to be informants for the FBI. He didn't ask, he said you and your buddies are going to be informants for the FBI. Mr. Mohammed Tanvir, who is a very religious man, kind of says on religious grounds, hey look, I'm not doing this. I'm not going to do this. This isn't right. This is unconstitutional. I have rights. I know my rights. And he says he's not going to do it. And then he, along with his 2 buddies, were put on no-fly list. So basically, they're treated as terrorists now. They can't leave the country. They can't go back home. They're really on lockdown, more or less. And they feel that this is completely unconstitutional. And so, in fact, they're suing Mr. Tanzin on grounds of the First and the Fifth Amendment. The First Amendment as, look, you have the freedom of religion, which he has the freedom to be Muslim, and he can't be prosecuted on the fact just because he is a Muslim, right? And the Fifth Amendment. And the Fifth Amendment, really the issue is that he has this consequence of being on the no-fly list when he never had the due process, right? So I'll bring this quote up from the Fifth Amendment. Nor be deprived of life, liberty, or property without due process of law. And in Mr. Tanvir's eyes, he's being restricted of his liberty. He's not free to leave the country. He's not free to go back home. He's not free to just take a trip to Las Vegas or Los Angeles. He can't. He's being stripped of his liberty without due process. He had no court. He had no attorney. He had no jury to condemn him. So that's where he cited the Constitution. He is also suing on grounds that this goes against the Administrative Procedure Act of 1946. And let's think back to 1946. This act was passed after FDR's creation of the New Deal. If we remember, President Franklin D. Roosevelt was creating all of these new government agencies in order to get America back up on their feet, to create more jobs, and to make us a world superpower again, right? And the thing is, although in a sense it did do that, right? The New Deal got us back on our feet. It's the equivalent of, Germany's building of the Autobahn. It put Americans back to work. However, it was called, all of these new government agencies were called a fourth headless branch of government, right? There was no one overseeing them. There was no checks and balances like there is in Congress, like there is in the judiciary, and like there is in the executive. And so with that, the Administrative Procedure Act passes, which is basically the rules for all government agencies. And on top of that, Mr. Tanvir is also citing the Religious Freedoms Restorations Act of 1993, introduced by, Minority Speaker Chuck Schumer. And the quote from this act that I think has to do the most with this law, which I think should be introduced to the Supreme Court, is that the RFRA, for lack of better words, prohibits any agency, department, or official of the United States or any state from substantially burdening a person's exercise of religion. And so Mr. Tanvir is saying that, look, this is against my religious freedoms. I have freedoms. They cannot be stripped away from me just because I am a Muslim, just because I am not an American-born citizen does not mean that you can put me on the no-fly list and treat me this way. So, in the Southern District Court of New York, the court denied Mr. Mohammed Tanvir. He lost. The FBI agent won. Of course, this case was appealed and went to the Second Circuit, and they reversed the district ruling and remanded it back down to the South District of New York. However, FNU, let's not forget, FNU stands for First Name Unknown, Tanzin, appeals it, and the Supreme Court accepts it. Now, although the case has not changed much, what the Supreme Court is going to be, out of focus there for a little bit, what the Supreme Court is really going to be looking at is not really whether this is unconstitutional, because, well, I think they already have sufficient enough evidence to say that this is unconstitutional. What they're going to be looking at most is whether the provisions in the Religious Freedom Restoration Acts allows litigants, in this case Mr. Mohammed Tanvir, to obtain appropriate relief against the government. Basically, this means, does Mr. Tanvir, not does he deserve it, but does he have the right to get government fiscal compensation for his struggles, his losses, right? And that's what the Supreme Court's going to be looking at this Tuesday. And with that, let's move to Rutledge versus Pharmaceutical Care Management Association, or PCMA, for lack of better words. So our two parties here are Leslie Rutledge, who is the Attorney General of the state of Arkansas, and PCMA, right? And this case is really Arkansas fighting back against Big Pharma. And Big Pharma has been really in the news quite a bit recently for maybe unethical payments, unethical charges, unethical campaign donations. Big Pharma has just been the bad guy in the news for a while. And so in this is Arkansas fighting Big Pharma, but more specifically, not just Big Pharma, PBMs. And what PBMs are pharmacy benefit management. And what these serve as are basically middlemen. They're a third party that really works between the insurance carriers of Americans like us and Big Pharma, the people who are creating the pills, creating the prescriptions. And basically what PBMs aim to do is they say, hey, look, we have all of these insurance companies under our belt, State Farm, Allstate, Farmers Insurance, right? And they say, hey, we want to do a wholesale. Give us a deal on these prescription drugs, right? We'll put them in the pharmacies. They'll be great. We have the customers. You have the product. Let's make this work. In a nutshell, that's what PBMs do, right? And the issue that Leslie Rutledge brings up is that PBMs really are not regulated. They are not charging the pharmacies and the insurances the same amount as the wholesale that they're getting these pills for, right? So if they're getting each pill for $10 and they're charging CVS $100 and Farmers Insurance $100, there's no regulations there, is what Arkansas is saying. And they're saying this is unethical. This must come to an end. And the second reason why this particularly is an issue in Arkansas is because Arkansas is a very rural state. Although there's larger cities, Little Rock, Fayetteville, the majority of Arkansas are small towns, places like Murfreesboro, right? And the other issue with PBMs is that they have allegiances. So big pharmacies like Walgreens, CVS are heavily associated with PBMs, and because the PBMs know that Walgreens and CVS is going to make them the big bucks, they're giving them all these pills for a much, much better price. Whereas, let's look at the small town mom and pop pharmacy in Murfreesboro, Arkansas. They're not going to be moving the same type of numbers that that CVS is moving. So in the PBM's eyes, why should they give them a discounted price? They're not giving us the revenue we want plus more, so we're going to pay them the same inflated numbers that we have been for years and years and years. And so in 2015, the Arkansas General Assembly, or AGA, introduces Arkansas Code 17-92 507, or Act 900 is what it's called. And this really introduced pharmacy acquisition cost. And this goes into the amount charged by the wholesaler based on invoice, meaning that what we talked about earlier, the PBM, if they're getting the pills for $10, they must, based on the invoice, which they must keep in their records, it's legal, they must give that same price to the pharmacies, or more, but not less, right? And the pharmacies, really, their argument is it should be more because, well, we not only are we paying for the pills, we have to pay for the prescription bottles, we have to pay for the air conditioning to keep all the pills cold and at the correct temperature. We have to hire pharmacists, we have to keep staff at the front. So there's, of course, there are all these extraneous costs that go into it as well. And so Act 900 mandates, quote, that pharmacies be reimbursed for generic drugs at a price equal to or higher than the pharmacy's cost for the drug based on the invoice from the wholesaler, end quote. And so PCMA, right, Pharmaceutical Care Management Association, their argument to this is that, well, this law is unconstitutional and is preempted, in fact. And preempted meaning that because this is a state law, it doesn't have superiority over a federal law. And the federal law they're citing in this is the Employee Retirement Income Security Act of 1974 and Medicare D. And with that, they're saying, look, we're already being regulated by both of these two laws. Why should we have another regulation from the state when we're already getting regulated twice at the federal level? And so in the first court case, the district found that the Employee Retirement Income Security Act was relevant to the case, yet Medicare D was not. So really, this case was a loss for PCMA, and this was a win for Leslie Rutledge in the state of Arkansas. However, PCMA appealed. Right, they appealed this to the 8th Circuit in St. Louis, which has jurisdiction over the districts in Arkansas, and that court remanded the case. Right, they said this is not correct. We're sending this back down to the district case, and you must change the outcome of the case. And the grounds that they did this were that Medicare D already is regulating the PBM's pricing and PCMA's pricing, and with that, so now we have one win for Arkansas, one win for PCMA. And with that, state of Arkansas, or Miss Leslie Rutledge, filed a writ of certiorari to the Supreme Court. And now we'll see what happens on Tuesday, October 6th. We'll see what the Supreme Court has to say about this. The next and the last case for this video, Google versus Oracle America Incorporated. Google, we all know Google, right? So let's look back to 2005 and when Google started negotiations with Sun Microsystems Incorporated. Okay, they started these conversations because Google wanted a licensing agreement to use Sun Java. Java was the code, the JavaScript, right? They wanted this program to develop Google Android phones, right? The phones that we still know and use today. However, like most deals, the deal eventually fell through. The two sides couldn't come to an agreement. However, Google kept and used a portion of the Java code for their Android phones and Android computer systems, all of the above, right? And look a little bit later, Oracle Incorporated buys out Sun Microsystems Incorporated. And once they do, now they own all property from Sun Microsystems, and Oracle sees that, look, Google is using our code in their Android phones to this day. So in 2015, Oracle sued Google for copyright and patent infringement. And in the Southern District Court of California, the court found Google guilty of copyright, but deemed that API, which are application programming interfaces, which is basically coding, right? This is what coding is. This is what the court calls coding. So it deems API packages not copyrightable. It's saying, look, this isn't physical property that you own. This is intellectual property that is fair game for Google in a sense, right? And with that, Oracle appealed to the U.S. Court of Appeals for the Federal Circuit, and they reversed decision on grounds that Java, quote, declaring code and structure, sequence, and organizations were entitled to copyright protection. So basically they're saying, hey look, the district court was wrong. This Java, it is copyrightable. And in fact, Google is in the wrong. They stole this property. This is copyright. This is copyright infringement. And so they remanded the case and sent it back down. And here in 2015, Google filed the writ of certiorari to the Supreme Court, but it was denied. So this did not get put to the Supreme Court at first. And so when it comes back down to the district hearing in Southern California, well, Google won again, actually. Because Oracle filed a judgment as a matter of law, which basically claims that Google doesn't have sufficient evidence for the case, so it can't even be heard. Google has no evidence. They can't claim that it wasn't stolen because it was stolen. There's nothing more to it. And with that, now that Oracle lost, they filed a writ of certiorari to the Supreme Court, and the Supreme Court did accept it. And that brings us to now, right? And now the Supreme Court is going to be tasked with two questions, I think. They're going to be tasked with, does copyright protection extend to a software interface, or is this intellectual property, right? Can a code, a universal code, be copyrighted? Can it be claimed as, hey, look, this is my property. This code is my property. You can't use it. And the second question that they're going to be asked was Google's use of this Java software in context of creating this Android computer program, was it fair use? Was it fair game? Or was it copyright? And with that, we will see this on Wednesday, October the 7th. Thank you guys for watching. Hope you enjoyed. Have any questions, comments, concerns? Go ahead and drop them in the comments. I'll make sure to try to get a reply to all of them. If you want to look at more cases that the Supreme Court has been looking at, go ahead and go check the channel out. I posted another video talking about the first two cases that the Supreme Court is looking at this term in October 2020. And if you want to know more about the Supreme Court, if you want to keep up to date with all of the cases that they go in, week out, go ahead and hit the subscribe button. I'm going to try to put up about video a week, maybe two, maybe three. But without further ado, thank you guys for watching.